Can you talk about how to fund a trust? I know that naming a trust in a will is not enough. It's definitely correct that naming your trust as the beneficiary in a will, that's known as a pour over will, does not actually fund your trust. Also, just having the trust document itself with the intention for everything to be in your trust doesn't fund your trust. So what trust funding is, it's the step after you've actually had your trust prepared by an attorney and you've looked it over and you've accepted it and you've signed the document. You then have to take an additional step of either retitling or transferring assets into the trust by assigning them into the trust, or potentially naming the trust as a beneficiary or a POD, payable on death, or TOD, transfer on death recipient for your assets. So the thing is this, the trust itself is simply a written document that states your wishes with regard to your assets. While you're alive, if you're married, what happens after one spouse passes away, what happens after both spouses pass away, who do you want everything to go to, what are the rules the trustee has to follow, important things like that, what needs to be done in order to properly administer your trust. Certain rules might be involved for taxes, things like that, right? So it's just a very large document usually, and it has a whole bunch of legalese in it. And the really core purpose of it is to talk about how your assets are going to be distributed, in what manner, what rules need to be followed, right? But the document itself doesn't have any power over the distribution of the assets, or just by having the document in place, it isn't like your assets are automatically, magically in your trust. That would make it really simple if it was. And unfortunately, far too often, I see people who think that. They think, hey, I signed this document, so now everything's owned by my trust. But that's definitely not how it works. After the document is signed and the trust, has its name, you actually know what the trust is called, then you need to do things like, if you own real estate, one thing that we do in Florida is we will commonly do a ladybird deed where the real estate would get deposited into the trust when the survivor who owns the real estate passes away. So the actual name of the trust is listed as a beneficiary on the deed. Some attorneys also use general warranty deeds to transfer property from the owner's names directly into the trust. So you're actually retitling the property, retitling on the deed, so that the deed now reads that it's owned by the trustees of whatever the name of the trust is. So it actually shows up as a different owner on like the property appraiser's website. For bank accounts, certain bank accounts that you want to keep in your individual name, because maybe you get checks or you get things that come into you, ACHs, in your individual name, then you're probably going to want to list your trust as a beneficiary, also sometimes referred to as a POD or a TOD for banks, but you're going to want to list the actual trust as the beneficiary rather than individuals. It's also a smart idea to have at least one bank account under the name of the trust. So this can be an already existing account that you retitle under the name of your trust, or you can open up a brand new account under the name of your trust. So the trust is actually the owner of the account. And oftentimes to do this, the law firm who prepared your documents should have also given you what's called a certificate of trust or a certification of trust. It's a document that can be given to the bank or whatever institution you're working with in order to either open up an account or retitle an account. And it provides all the information that the institution needs in order to make sure that the account is now under the name of the trust, without having to give them your full and confidential trust document. And this goes the same for things like investment accounts, money markets, which can easily be retitled into the name of your trust. And you can do this again by giving the institution who has that asset the certificate of trust so that they know how to properly name the new account. So there's different things that need to occur for things like businesses. You don't retitle your business into the name of the trust. Of course, it can keep the same business name, but let's say you have an LLC and you own membership units in that LLC. Well, you can actually assign those units to the trust, or if you have shares of stock in a company, you can assign your shares of stock to your trust so that your trust now becomes the owner and they can pass to your beneficiaries outside of probate. You can also assign rights like copyrights or trademarks into your trust. So these are things that you have assignment forms for in order to make sure that they're owned by the trust. So it really just depends on the particular asset, what you need to do in order to either transfer it into the trust or make sure the trust is listed as a beneficiary. But this is a very important step, and if it's not done, it means your assets go through probate. And one other thing I want to clear up, because it is mentioned in this comment about, I know that naming a trust in a will is not enough. So this type of will, again, like I said in the beginning of the video, is called a pour over will, because the intention is that your assets, whether they were actually transferred into the trust or not, are to pour over into your trust. However, just because you named the trust as the beneficiary in the will does not mean it's an automatic pour over. What I mean by that is, if you don't do this step of funding your trust that I just talked about, transferring the assets into your trust, assigning them, retitling them, if you don't do this step, any asset you left out does need to go through probate, whether you have a pour over will or not. All the pour over will does is let the probate judge know that you have a trust, and the trust is the rightful beneficiary of the asset, so that when the probate proceeding is done, that asset can be rightfully deposited into the trust. So I've often come into this with clients where they think, oh, I have a pour over will, so if I leave something out, it's no big deal, because automatically at my death, the pour over will is going to make sure it pours over into my trust. Well, that's not what happens. If it's not titled properly and you end up passing away with assets that are titled just in your name, they're not in your trust, they don't list the trust as a beneficiary, they don't have another beneficiary, those assets are going to have to go through probate, pour over will or not, and they will just deposit into the trust at the end of probate. So I hope this answers the funding question. If you have any other questions about estate planning, asset protection, probates, and you're in Florida, please don't hesitate to contact our office at Cause Law Office. We're the non-stuffy attorneys, and we're located in Clearwater, Florida. The link is in my bio.